Some audio would help. Sorry about that, folks. This is an impromptu live stream on a topic that a microphone would be good too. This is a very, very impromptu live stream. But, you know, we've done a lot of talking lately about the GOP, about Christina Caramo, all that stuff. And we definitely need to have more shows on different topics. And tonight, I just have a random stream on a random topic for those who might have tuned in. Last night, there was a little bit of a show open and then some banter in the very beginning about copyright law. And someone in the comments had referenced this book by a gentleman named Stephan Kinsella. And I kind of flew off the handle a little bit. I was like, oh, that book is garbage. Let me tell you about that. Not right now, but sometime we should. And I thought that was kind of strange. But I'll tell you, folks, you know, when you read a bad book of fiction, you kind of forget about it pretty quickly. When you read a good book of fiction, you forget about it pretty quickly, I find. But when you read a really, really lousy nonfiction academic book, and as you're reading it, you realize how bad it is, it really stays with you. And that kind of set me off. There's not very many times this happens. You know, usually when you read a book, you know, it's a book that's something you probably, kind of sort of already believe, and so they're not really challenging you very much. And if it reinforces what you already think, well, great. If it gives you more facts to marshal to your arguments, wonderful. And every once in a while, though, there's a book that you realize is just completely full of crap. Like, here's one, for example, No-Go Zones by Raheem Kassan. I genuinely wanted to know, how is Sharia law coming to a neighborhood near me? Because I've heard about this from a lot of people. It's like, let me get this book. I'm sure it'll have a lot to say on the topic. And the entire book from cover to cover is argument from anecdote. Like, shame on Nigel Farage, who blurbed the book saying, this book should be required reading for conservatives, Republicans, liberals, teachers, students, reporters, editors, and activists all alike. Now, this is a book that would be embarrassing if other people actually read it. And, well, anyway, it's the topic for another night. The topic for today is this book, Against Intellectual Property, by Stephan Kinsella, or as you can see, I actually crossed his name off and wrote my own in because, hey, it's intellectual property. We don't believe in intellectual property. This is my argument. Of course, that's absurd. I would be embarrassed to have published this book, but I'm going to go through this. This is a libertarian thing, and maybe I'm just being a libertarian geek on this, talking about this stuff, because as the book accurately does say, by the way, here it is, they did have the courtesy to publish the entire thing online for free, but it's the Mises Institute. They typically do that. And yes, by the way, they do assert their copyright. Here, let me make this bigger. They do, of course, assert their copyright on this book. But I actually read this book when I was working in Washington for Kerry Bentivoglio as a congressman, because he was on the Small Business Committee, and they were actually talking about making amendments to the America Invents Act, which was coming up for reauthorization after 10 years. And my father's a patent lawyer, so I do care about intellectual property law. It's very interesting. And anyway, as the book does note, there is actually a spectrum of libertarian perspectives on intellectual property. And they say, starting from, like, on one end is obviously himself saying that there shouldn't be any IP. This argument in his whole book. The other end would be probably Ayn Rand. I think he quotes Ayn Rand. But this book is so bad in how it argues everything. I'm not going to go through it word for word. It's, but it's not long. It's not a long book. It's only 73 pages. But this is an interesting question, isn't it? Because intellectual property is an important topic. And the question of how we use and reuse other people's content in all kinds of different ways. We've had issues recently with people videoing events and recordings. And are you allowed to say that you can't record this? Are you allowed to take some other people's ideas? Are you allowed to collage from other people's songs? And all these are very interesting questions. And this book does not very well get into any of them. In fact, it's amazing how little distinction is made amongst almost any kinds of content, starting with, the biggest thing is they have these definitions in the beginning about, let me make this a little bit smaller so I can scroll through it more easily. So they mentioned the distinction between patents and copyrights in the beginning. Everything else in this entire book treats patents and copyrights like they're the same exact thing, which I think is probably the fundamental biggest problem that this book makes, because they're two very completely different things. A copyright is for a creation, whereas a patent is for a discovery. That is, to me, that is the huge distinction. Is, if you compose, say, a movie, you spend hundreds of millions of dollars to make a movie, and you have no copyright protection, so therefore anybody else, the day it's released, can send the entire movie out to the rest of the world, and therefore make it so you no longer have the ability to capitalize on your own creation. That's a problem. That's not the same as a patent, which is where do patents come from? Typically, competing companies that are trying to find ways to innovate in ways that they can get ahead of their competition. So they're driving towards the same thing, right? If you have a patent for, well, my father's claim to fame as a patent attorney was he patented a method by which the two motors in a hybrid vehicle are sized relative to the others. In fact, that wasn't the main point of the patent. The main patent was called Hybrid Motors Incorporating Turbochargers. But this one part of the patent on the relative sizing of the motors, turns out every modern hybrid vehicle infringed upon. Made his client a lot of money and himself by extension. But every other company was trying to do the same thing. His client came up with it first. So they weren't two completely separate entities doing completely separate things. They were both driving towards the same technological goal. You see? So it's a discovery they're looking for. That's a different thing. But this book does nothing to differentiate between copyrights and trademarks. So there's a bunch of strawman arguments. There's barely mention about trademarks in the book, although it is on this particular page, but it's here just to define what a trademark is. And actually, I think this section on trademarks, because they touch on it at the very, very end, really goes to the intellectual laziness of this entire book, which is apparently a landmark home of libertarian philosophy. So this is his argument on trademarks. He says, so, and by the way, this is, I'm sorry, guys, very, very bad libertarian humor here. Jonathan Chapman says, identify as chair today. Yes. So here's what he's talking about trademarks. So he's quoting somebody else. Trademarks, this so-and-so argues that trademark law is legitimate. Suppose some Lochmanian changes the name on his failing hamburger chain from Lochman Burgers to Rothbard Burgers, which is already the name of another hamburger chain. I, as a consumer, am hungry for a Rothbard burger. I see one of the fake Rothbard burger joints run by the stealthy Lochmanian, and I buy a burger. Under current law, the Rothbard, the owner of the Rothbard Burgers trademark, can prevent the Lochmanian from using the mark Rothbard Burgers to sell burgers because it is confusingly similar to his own trademark. That is, it is likely to mislead consumers as to the true source of the goods purchased. The law then gives the right to the trademark holder against the trademark infringer. Again, terrible libertarian humor, Lochman Burgers and Rothbard Burgers. But then he goes on. In my view, the right of the consumers who are violated, not the trademark holders. Wait a second. So, okay, let's get away from this Lochman Rothbard garbage. So, suppose you set up a burger joint and you call it McDonald's, and you serve something even. Well, that's a bad example because McDonald's wouldn't want to be. Let's say you open a burger joint and you call it Five Guys, but you're serving McDonald's quality food. According to this guy, it's not Five Guys' rights who are violated. It's the consumer's rights because the consumer's getting the bad burger. Well, yeah, but they're also getting the bad burger that they thought was a Five Guys burger. So obviously that damages Five Guys because now you're serving garbage and you're damaging their brand with it. This doesn't make any sense at all. So he says, it appears that under libertarianism, trademark laws to give consumers, not trademark law, the right to sue trademark pirates. Oh, and why would they do that? Like this came up recently. There's a certain apparently confusion regarding the trademark of the Michigan Republican Party. So how would they're saying, okay, so it wouldn't be, say, the actual Republican Party going after Christina Caramo for running a fake party. It would be the precinct delegates that'd be harmed. Does that make a word of sense? No, that makes no sense at all. But that's the gist of, that's where a lot of this book just completely falls apart. Let's look at some of their, it's mostly straw manning arguments. So okay, who cares about libertarian perspectives? Utilitarian defenses. Again, this is like straw manning. Utilitarians hold that the end of encouraging more innovation and creativity justifies a seemingly immoral means of restricting freedom of individuals to use their physical property as they see fit. But there are three fundamental problems with justifying any right or law on strictly utilitarian grounds. Again, no distinction between a discovery and a creative work. So if I just put my name on his book and start shopping it around and saying, hey, buy my book on intellectual property law, not that I would put my name on this turkey, but on anyone else's book, what would happen if I'm somebody famous, like Bill O'Reilly, and I want to just take the work of some nobody that I stumble upon? Well, then who's more likely going to, if you don't have any right to go after somebody for stealing your work, who's more likely to profit then from it? I mean, the moral arguments are just completely lacking in this. It's like libertarians think there are undoubtedly costs of the patent system. Yeah, of course there are. As noted, patents can be obtained only for practical applications of ideas, but not for more abstract or theoretical ideas. This skews resources away from theoretical R&D. Well, that's because you have to be able to define the invention, because that's as far as patents can go. Oh, by the way, I think actually, as I said, I think the distinction is between patents and copyrights. I think, and I know my dad would hate to hear this because he's a patent lawyer, but I think there should be very, very much stronger, circumspect rules on patents, because there really is very, very loose patent law. And there's a standard called obviousness. If something is too obvious, you can't patent it. But who decides what's too obvious? And the answer is it's completely arbitrary and unfair all the time. And my dad's reaction to that would be, well, yeah, but how do you define, how would you put into statute what's too obvious? It's like, well, they have managed to put everything else in the universe into statute. They'll come up with something. But in the end, I think they should err on the side of caution, because the way our society was founded was, until the Patent Act in the 1950s, there was only the U.S. Constitution that defined what patent protections were. And the courts constantly, like decade after decade after decade, the courts would say this was not intended to cover gadgets. And they would always have language like the creative spark, the spark of genius, the true innovation, something landmark. That's what intellectual property, that's what patent law was supposed to cover, was discoveries and real inventions, not gadgets. And the courts consistently were erring on that side until the Patent Act. And that created the patent bureaucracy. And what happens then? Well, then the patent bureaucracy goes into full effect. And what do they start doing? Well, they say, okay, this patent is too obvious. Okay, let me rewrite it a little bit and send it back in. And that's what almost always happens when you get a rejection, unless you can prove prior art, which is a separate issue. But if they just say this is too obvious, okay, well, then make it a little bit narrower, put a little tweak in there, patent issued. And then suddenly no one can take that for I think it's like 17 or 20 years. I forget it. I took the patent bar and I was 22 and took the patent bar. I got 100%. But that was a long time ago. I don't remember if it was 17 or 20 or sensible to win, but if you think about it, what happens when a company has the ability to get a government granted monopoly on an innovation for decades? That's problem number one. Problem number two is the pace of technological innovations is increasing. So what might have been, we get this term from 17, 18 years, whatever it is for a patent. Well, that was the term that was what they chose in the 1950s, but and there's all kinds of exceptions and things that they're putting in now. But generally on the side of keeping them extended, and that's a problem, folks, because when you get to where innovation is going to come more and more and more rapidly, or especially if AI is starting to develop things, well, and these are now questions that have come up. There's this George Carlin lawsuit. Can AI create novel material based on the voice print of a dead comedian? I mean, that's what they might be in trouble just because they've marketed it as a George Carlin bit. But these are serious questions, and we're against IP as libertarians is not a serious book. So short rant for tonight, short stream. I just had to get this off my chest because I touched on this on the show last night. I'm like, why is he talking about this book? And I just kind of went off on this rant about this Stephan Kinsella book. And I think there's a big difference between patents and copyrights. I don't think it's well understood. And I don't think this is an easy answer that fits into. I mean, look at how narrow this book is. This is like a, this is a journal article basically. And it's a much, much more in-depth, complicated question than that. So overall, not a fan of Stephan Kinsella. That's all I have to say about intellectual property for right now. So there we go. Updates on the cases. Tomorrow, there will be the hearing in Grand Rapids. We will have coverage on that tomorrow night. I have heard that the Ingham County case, the case against the case that Christina's MIGOP brought against Comerica Bank has been adjourned until I want to say March 7th. So there should be probably nothing on Thursday, but so I'm getting that short rant for the time being because I do like to cover other topics on the show. And I know that the KK stuff has crowded everything else out. There is a lot more to say on current events on, I've been wanting to do a show for a long time on what's going on in Ukraine, stuff about privacy, civil liberties. And I just wanted to get this off of my chest because it was bothering me all day. It was like that book. I know I've got that book on my bookshelf. Oh, I didn't get to answer that question. I wonder what people are thinking about that. I wonder what Dennis thinks about the fact that I didn't answer his question and I kind of put him down over it, yada, yada, yada. So I don't know, guys. This is one of my few very short kind of weird topic streams. Let me know in the chat or in the not in the chat, in the comments. Let me know if you like this, if you want to see more streams like this. Otherwise, it'll be back to current events, back to the normal stuff, court case coverage, Lansing coverage coming very soon, all that coming soon. So that's all for now. And thanks for tuning in. Until next time, thanks for all you guys do for liberty. Peace.